Today, we're diving into a critical and controversial topic, the legality of pharmaceutical companies sponsoring foreign travel for healthcare professionals. This issue has garnered significant attention, especially after a high-profile case involving a pharma company, which spent rupees 1.9 crore on trips to Paris and Monaco for doctors. Let's break down the legal framework, analyze the implications, and discuss what it means for doctors and pharmaceutical companies. Here's the context. A pharma company organized trips for healthcare professionals to learn about aesthetic procedures like Botox and anti-aging medicine. However, regulators flagged this as a violation of India's pharmaceutical marketing regulations, sparking widespread debate about ethics and legality. Let's first understand the legal framework governing such practices. Number 1 is the Uniform Code for Pharmaceutical Marketing Practices, or UCPMP. It prohibits pharma companies from offering travel and hospitality to healthcare professionals and aims to prevent unethical marketing practices that could influence medical decisions. Number 2 is the Medical Council of India, now the National Medical Commission, Regulations of 2002. Section 6.8 explicitly prohibits doctors from accepting travel facilities from pharma companies, and violations can lead to suspension or cancellation of medical licenses. And number 3 is the Prevention of Corruption Act of 1988. If government-employed doctors accept such benefits, it constitutes corruption under Sections 7, 8, and 9. Companies offering these benefits can also face penalties. Now, let's analyze why this case is problematic from a legal standpoint. Number 1 is the professional service agreements. The pharma company claimed these trips were part of professional service agreements, but investigators found no clear justification for international travel. The timing and nature of these trips suggested they were incentives rather than genuine educational initiatives. Number 2 is the tax implications. These trips could be classified as benefits in kind to doctors, attracting tax liabilities. Pharma companies attempting to claim such expenses as business deductions risk tax evasion charges. Number 3 is the institutional responsibility. Hospitals approving such travel face questions about their policies on conflict of interest. Proper documentation and transparency are critical, but often lacking. Several landmark judgments highlight the seriousness of this issue. Case number 1 is Dr. K.L. Tripathi versus State of Uttar Pradesh 2001, where the Supreme Court classified accepting benefits from pharma companies as misconduct under medical ethics. Case number 2 is Vinod Jan versus Medical Council of India 2004, which affirmed that disciplinary action is warranted for doctors accepting travel sponsorships. Case number 3 is Federation of Medical Representatives Association of India versus Union of India 2022, which called for statutory backing to the UCPMP to strengthen enforcement. Here are some actionable recommendations for all stakeholders. Pharmaceutical companies must implement compliance programs and document all professional engagements clearly. They must opt for virtual training platforms instead of sponsoring travel. Healthcare professionals must avoid engagements that may appear as conflicts of interest. They must ensure transparency and proper documentation of any professional services rendered. This case underscores the evolving regulatory landscape in India's pharmaceutical sector. While collaborations between pharma companies and healthcare professionals can be beneficial, they must comply with ethical and legal standards to avoid scrutiny. The trend is clear. India is moving towards stricter enforcement and possibly statutory backing for marketing codes. All stakeholders should err on the side of caution to safeguard their reputations and legal standing. Subscribe to Dr. Lawyer Official for more medical legal insights.